And the Court of Appeal has issued stay orders stopping proceedings of a 5-judge High Court bench that was constituted to hear a petition challenging former CJ David Maraga's advisory note to the President to dissolve Parliament on the 2/3 gender rule. An appeal had been filed by the National Assembly and the Senate against the dismissal of their application that was challenging the powers of the Deputy Chief Justice Philomena Mwilu to establish the bench. And as KTN's Daniel Kariuki reports, the cases will now remain suspended pending the determination of the appeal.
Application case at the High Court of Appeal in Nairobi between the National Assembly and the Senate as first and second applicants respectively, and Chief Justice and Attorney General as first respondent and second respondent, with the Deputy Chief Justice as interested party. The applicants requested the Court of Appeal to issue an order staying further proceedings before the High Court at Nairobi in petition contesting the dissolution of Parliament as advised by former CJ David Maraga, pending hearing and determination of the intended appeal. The applicants were seeking interpretation of Article 165(4) of the Constitution that assigns the CJ to constitute a bench to hear a case that raises substantial questions of law. The advisory to dissolve Parliament having been given by the then Chief Justice David Maraga, who retired before constituting the bench, the mandate was therefore handled by Deputy Chief Justice Philomena Mwilu, who was acting Chief Justice, prompting the National Assembly and Senate to move to Court of Appeal and launch an appeal calling for the interpretation of Article 165(4) of the Constitution on whether the Deputy Chief Justice was empowered by the article to empanel a bench of the High Court. 3-judge bench of Judges Roslyn Nambuye, Wanjiro Karanja and Ole Kantai have now issued stay orders on all further proceedings of the 5-judge High Court bench constituted by Deputy Chief Justice Mwilu to hear the petition challenging Maraga's advisory to the President for Parliament to be dissolved on the 2/3 gender rule. The 3-judge bench has, however, given 30 days for an appeal of the decision. Critics say the move might delay a case, a delay that will see Parliament term come to an end, where if constitutional changes being advocated by BBI are implemented, Maraga's advisory will be overtaken by time. In 2020, former Chief Justice David Maraga asked President Uhuru Kenyatta to dissolve Parliament over failure to enact the 2/3 gender rule. Maraga argued the August House cannot escape the wrath of the law for its failure.
Current Chief Justice was appointed by the 11th Parliament. It still did not have the 2/3. So are his actions lawful? Because it will mean that he was appointed by an unlawful house.
However, IEBC in the submission said Kenya will be thrown into a constitutional crisis should President Uhuru Kenyatta dissolve Parliament. Sentiments echoed by political scientist Professor Mutahi Ngunyi, who argues if the President dissolves Parliament, he will have prolonged his tenure by a further 3 years, while Kenya will have the 13th Parliament.
So if we go today, he dissolves Parliament.
Yeah.
Then the presidential election will have to happen in 2025.
Yeah, yes, that's right.
That is a constitution, and you need to go and read what the Attorney General's prayers to the courts looked like. Now that gives him an extra 3 years. So that way, he is happy.
Court of Appeal stay orders therefore means High Court will not proceed with the case challenging the advisory until the case before it is heard and determined. Daniel Kariuki, KTN News.